the Judge Silberman.
Sorry about that.
That's all right. We have everybody back. We have the panel and we have counsel. Mr. Manganiello, I believe you are here on behalf of the appellant.
I am, Your Honor.
Would you like to reserve any time for rebuttal?
5 minutes, please, Your Honor.
I will try to do good and let you know when you get there. It seems the last case I didn't have so much luck. I was late. So hopefully you will allow me to get a winning streak going. All right. With that, we are ready to proceed. Mr. Manganiello, the floor is yours.
Thank you, Your Honor. And I, as you mentioned, represent the Hazeltons. We're here to discuss and to challenge specifically the imposition of a mandatory injunction regarding my clients. As the court is well aware, injunctive relief is an extraordinary, drastic remedy, should be granted only cautiously and sparingly, particularly in the instances of mandatory injunctions, which are looked upon with even more disfavor. That's the exact sort of injunction we have here today. Essentially, what the association has sought and ultimately received was an injunction, a mandatory injunction, requiring the Hazeltons to repair or replace, and ultimately it was replace, their windows. And because the association failed to establish at trial a number of elements of their injunctive relief, we believe that the injunctive order should be reversed as it relates to the portion of the injunction directed at my client to replace the windows. First and foremost, the association absolutely, unequivocally has an adequate remedy of law. Trial testimony established very clearly that the association had the ability to do exactly what they requested an injunction to require my client to do. And they had the ability to charge my client any money associated with replacing these windows. That express right is crystal clear in the declaration, but further, it is also fully given to the association in the property management agreement that is signed and was in place when all this popped up between my clients and the association. There are two cases right out of the great second DCA directly on point on this issue, and we believe those are the Lorda case and the Maoriello cases. Both cases standing for the proposition, look, when your declaration gives you the absolute right to do what you're trying to get an injunction for, and by the way, it gives you the right to seek the funds associated with doing it, you just simply can't satisfy that element of an injunction that you don't have an adequate remedy at law. Specifically in the Alorda case, the court found that the association couldn't get an injunction requiring the unit owner to get insurance because the declaration let them get insurance and charge it back to them. Maoriello, even more directly on point, said that the association couldn't get an injunction requiring the unit owner to maintain their lawn. The court found very distinctly that the association's declaration gave it the option of remedying the alleged violation itself, assessing the owner for the cost, and if the owner failed to pay, placing a lien on the property and foreclosing it if it remained unpaid. That is the exact undisputed factual situation that we have here in this case. The trial court relied on case law cited by the association, the same case law cited by the association in their answer brief. These cases address the separate and distinct element of irreparable harm. Now, there is some overlap in that kind of analysis, and however, none of the cases cited by the association, and in fact, no case cited by the lower court or anyone in this matter has ever found that an association that has the clear right to do something under their declaration has the ability to get money back for the costs associated with doing it, that is not an adequate remedy law. It just simply is.
Question for you, in the Emilio decision, which I believe the author of that is on our panel today. There's a passage at page 1041 of the opinion where it points out that the condo unit owner didn't have the power and wasn't the cause of the problem in that case. It was a slab for which only the condo association had the right. Here it's a little bit disputed about where the cause is and who has the ability, isn't it?
Well, it's disputed as to whether or not my client had the responsibility or ability to fix it. That's disputed. And when I get into the fact that they didn't establish a legal right to have my client fix it, you know, they didn't meet that element either. But the reverse is not true. There is no dispute the association had the absolute right to do this exact repair. There's no dispute that my client affirmatively stated, if you want to do this repair or you think this repair is necessary, go ahead and do it. We'll fight about who has to pay for it, but you go ahead and do it. So there's no dispute whatsoever that the association had the ability to do this repair. And the declaration clearly allows for it. The separate property management agreement signed between the parties, because they were also the association was also the rental agents for this property and fiduciaries to the Hazeltons. And as Judge Silberman wrote in the Emilio opinion, he talked about how the Emilios had no ability to remedy the problem, that they have no unilateral right under the declaration of condominium to maintain, repair, or replace the floor set. That's exactly the opposite situation here, where the association undisputedly has the unilateral right to do those things.
That Emilio is distinguishable on its facts from this case.
Well, yes, I mean, I agree completely with the reasoning in Emilio, but you apply that same reasoning here, and because the association does have that unilateral right, the inverse is true, as Emilio would imply. I think Emilio supports
it a unilateral right that it has, or does the homeowner have any duties under the declaration?
So it was argued that the homeowners have a duty to do this. But
condominiums are a unique form of ownership in the state of Florida. And it impacts,
sure.
Innocent third parties that may have the same wall where this water is running down. And also has the ability to assess homeowners. So what you're saying is my homeowner doesn't wish to pay for it, assess the rest of them, and then let us litigate it out. And I'm just wondering what happens if every home unit owner does the same thing? How does a condo association finance all this?
That's not what I'm saying at all, Your Honor. I'm saying it's because this exact situation, why the injunction's inappropriate. You do this repairs, you don't assess everybody. The declaration and the property management agreement, but the declaration has them assess the Hazelton directly.
Mr. Manganiello, in the real world, for the condominium association to make the repairs, it has to have money in the bank. And when it pays for those repairs, it has to pay for other things too that are general expenses of the association. So one way or another, if they're deferring the reimbursement for the repairs they're going to make to the single unit owner's unit, the association is not necessarily able to finance all of those things. So now they have to increase their assessments to cover, while they, in this case, gone on for 10 years. So now they've got another 10 years of litigation to recover the cost of the repairs and enforce their lien and all that. How is that not? That is, to me, is the very definition of an inadequate legal remedy.
Well, so there's two parts to that, Your Honor. The first part is that there was no evidence presented at trial, and they do have the burden of proof on this element, of any kind of disruption of funds that would have taken to do what was a relatively modest $20,000 or so repair that was suggested when this all started. So there's no evidence, and they do have the burden of proof of establishing that element. The second response to your question, Your Honor, is the fact that there wouldn't have been 9 years of litigation. And if there would have been, it would have been a repair done, no more damage happening, no more leaking happening. And then, okay, let's litigate about who has to pay for it. But that would be us challenging it because they have the ability to file a lien and to foreclose the house. It would have to be up to them, us to then challenge it if we're not going to pay it. So these absolute rights are put in place for a reason. And as you'll see, this is also a situation where there wasn't a clear legal right to have my client have to replace these windows. These are exterior windows to the unit. The association not only has the absolute right to do this work, but they also have the reverse. They've got the power to prohibit and prevent my client from doing it. And that's what the evidence showed in this case actually occurred when my client tried to mitigate their damages and first tried to do repairs. The association took the position, well, you can't repair those windows. They have to be completely replaced. We don't think repairs will work. And then eventually when my client said, okay, well, let's mitigate the damages, I'll just do these replacements. They went through a number of contractors and bids for a number of years that the association rejected. This is the kind of complicated, scenario that the extraordinary, remedy of injunction, it's just too messy and it doesn't work. Specifically, when it talks to legal right, the legal basis and the legal responsibility that the association states my client has under the declaration to do these repairs or replacements of their windows is under the 1998 amended declaration, which says if a unit owner makes any modifications. In this case, the undisputed facts were in 1997, the subject windows were put in. There was no unit modifications to the windows after that point. And then in 1998, the association decides, well, if any unit owners start making any more modifications, they're going to have to pay for these things. The language expressly in the declaration is prospective. It says if a unit owner makes. It doesn't say unit owner modifications are the responsibility of the unit owner. It doesn't say any unit owner modifications. It doesn't say if a unit owner made or makes. It just says if a unit owner makes. It's exclusively prospective. As the court, I'm sure, is well aware, these association phraseologies, I think it's clear it's only prospective, but if there's any question about whether it can be applied retroactively, that interpretation is against the association as the drafters of the of their own declaration and language. So I think the declaration itself makes it actually the association's responsibility to do this work to begin with, but there's certainly not a clear legal right to require my client to do so under those facts. And that's the facts that they were proceeding on in the section of the declaration that they ultimately utilized to obtain this injunctive relief. There is no question that these exterior windows are either common elements or limited common elements as defined in their declaration. And there's also no question that the declaration requires the association to maintain and replace the common and limited common elements. Now, even if the court applies this prospective language, if a unit owner makes a modification to past modifications, because at that point, now you have a declaration that says it's the unit owner's responsibility because it's a modification. And then you have the other section where it says it's the association's responsibility because it's a common element or a limited common element. Neither section says, okay, it's the association's responsibility unless it's the unit owner's. And the unit owner section doesn't say, and this absolves any concurrent responsibility by the association. So at best, if you apply this prospective language retroactively, you would have the situation of potentially joint responsibilities because these are outside the boundaries, as we put forth in our brief, of the unit. These windows are to the exterior of the boundaries of his unit. So for those reasons, again, I think it establishes it's the association's responsibility, but there's certainly not a clear legal right to this. And again, we want these windows, if they need to get replaced, if the association says it needs to get replaced, they need to get replaced. And they've got a clear legal right to do it. this mishmashed legal argument that you end up fighting for 9 years demonstrates that this is not the kind of clear legal right that should trigger this extraordinary remedy of injunctive relief. When you go, even further into the analysis, there's this whole nother level of, there's a property management and rental agreement between the association and the Hazeltons at the same time. And we outlined in the brief, I won't go through every single point, but there are numerous fiduciary duties, maintenance review responsibilities, and absolute rights to do any of the things that, including making these sort of repairs if they believe it's necessary. And they obviously
you're right at
believe it's
15.
necessary.
You're at
I'm sorry,
15
Your
minutes,
Honor.
Counsel. You are at 15 minutes.
Thank you. Just to wrap up again, the evidence showed, and people, the parties argued back and forth about, okay, well, you didn't use this contractor the right way, or we don't think repairs would have worked, those sort of things. The bottom line, though, is that the association prevented the Hazeltons from trying repairs to see if it would work, and then prevented a number of contracts of going forward to replace those windows. That's where we go to our unclean hand argument, but it also supports the fact that they didn't establish that allowing this injunction is in the public's interest. The mess of this case and the fact those windows were left leaking for 9 years demonstrates why this is not how this can be done in Florida. This is not the way to handle these situations. If an issue needs to be done and the association believes it needs to be done and they have an absolute right to do it, they've got a clear legal remedy. It's not in the public's interest to first litigate about it and try to get an injunction for 9 years while this water continues to drip and while they control the ability of the homeowner to make repairs or to replace the windows and prevent it, and then have it only fixed 9 years later. It's just simply not in the public interest, and I'll save whatever I have left for rebuttal. Thank you.
Thank you. Okay, let me stop the clock. Counsel, I want to ask your help before you start. Is it pronounced Macaulay? McCall? I want to get it right.
It's McHale.
McHale. Thank you.
May it please the court. Kevin McHale on behalf of Fisherman's Haven Association, Inc.
So all
Your
they need
Honor,
is a green uniform, right?
that's right. About
Kevin McHale.
a foot of height.
We won't talk about that, but yeah, that's good. I appreciate that, counsel. Thank you for helping me. You may proceed.
Yes. The crux of this case, Your Honors, has always been about maintenance and repair obligations for interior unit alterations under the Declaration of Condominium. And specifically, the appellants, the Hazeltons, rejection, and as we see today, continued rejection of those specific obligations that are required of unit owners. At trial, the court correctly found that the association proved violations by the Hazeltons of the Declaration, and in turn, Chapter 718, by their refusal to perform these maintenance, repair, and when necessary, replacement obligations. Replacement obligations that are required of owners with alterations, the modified and closed lanais, and that their refusal to take action constitutes irreparable harm without an adequate remedy to warrant injunctive relief that's specifically authorized by statute. That's section 718.303. And as seen in their briefs and the argument today, they continue to reject that obligation, continue to argue that it's common elements. 3 judges in this matter.
Mr. McHale, before the balconies were enclosed, were the balconies considered common elements, or were they considered belonging to the unit owner?
They were considered limited common elements, and then they were converted to unit owner property.
Is there something in the paperwork that established that the association gave up the right to those being shared joint common elements or limited common elements?
Yes, the recorded declaration did.
And what did it say?
And it said that if an owner alters a unit at section 10B8, that they assume possession and control and the responsibility to maintain, repair, replace those unit alterations.
And that declaration came into place after this unit had been modified?
Well, that part is unclear. There was a 1997 construction plan that was noted at court for alterations of this specific unit, which work included grading the original slope floor, enclosing scuppers for water when that outside outdoor balcony was converted to an interior lanai. And what the association did was they said, listen, owners want to do this. The building was built in 75. All units had open air balconies. This was a factual finding at trial. And the drawings noted all units had open air balconies, no lanai enclosures. And the declaration was amended to allow owners to do this. And
so really the question that I was trying to get to is, if this balcony was converted prior to the declaration being recorded,
yes,
what puts a subsequent owner on notice that that particular unit's limited common element has now become property of that unit owner?
Yes, and that is, as was established at trial, that these owners took title to their unit in 2009.
No, I know that they took it after the declaration, but again, taking out just the facts of this case for a moment,
Yes.
if the balcony was enclosed prior to the declaration being recorded, the declaration is then recorded. Does the declaration on its face say any unit which has an enclosed balcony is now the proud owner and maintainer of what used to be a limited common element? Or is that an interpretation that you're suggesting?
That's the interpretation by the three judges before us at the trial court, that these alterations, if they are made, the unit owner takes title subject to the restrictions in place at that time that they took title. And there was clearly a conversion from outdoor balcony to create this additional interior living space. And in exchange for the right to do that,
So if someone enclosed their balcony in 1979, just to pick a number out of the air, that declaration, and I'll need to go back and read the language carefully, but that your position is that declaration absolves the association of any entitlement to assert it is a limited common element, even if it was done years before.
So in that situation, yes, it would be. If that owner continued to own the unit, they might be grandfathered in. Units who take subject to the title subsequent to that wouldn't. But there's another kind of issue here, and there are components of windows. There's flashing. There's the window.
No, and I understand there may be certain aspects of it that are still common elements, but what you just said is really significant to me. If someone who made this change and didn't sell the unit would be grandfathered in so that it is still a limited common element, how is a subsequent, well, potentially, how is a subsequent owner supposed to know that they are now assuming the obligation for everything that was done before when the seller may not have had the obligation to make the repairs? When the seller, had the seller kept the property, they wouldn't have had that obligation.
First, the issue regarding being grandfathered in was not before the court at trial. There was no dispute. They took title in 2009.
No, but the point, and the point I'm trying to make is, can you have a limited common element for one unit owner who has enclosed the balcony and they didn't sell, but it's still a limited common element? But for somebody who sells their unit, now it's not a limited common element. Does the declaration make that distinction?
The declaration that I'm aware of does not make that distinction. But again, that wasn't before the court because it had been determined that they took title in 2009 subject to this altered enclosed unit. And that would create a management nightmare for an association that say, okay, well, this flashing was predates the amendment. That component there postdates the amendment, so we need to manage, maintain, repair that. But the owner does this, and it's if you have a balcony, an outdoor balcony that's original to the construction in 75, that would be a limited common element. If you have an enclosed lanai, the way that we have here with this interior additional space, that is the unit owner's responsibility to maintain. And the court made these litany of evidence presented at trial, these factual findings that was open air balcony, it was enclosed.
It just seems odd to me that if someone had made the change before the declaration and they did not sell, their unit would have a limited common element, but for the other 90% who have sold their units, they're now responsible as the buyer for what the seller was not responsible for. That's a really bad way to ask the question, but I think you might have understood it.
I do, and the response to that would also be that the owner who buys it, they're on record notice of the governing documents that are recorded in the official records. So they are on record notice that the original building had this provision. They had open air balconies, that the declaration was amended to allow owners to convert this, and in exchange for that right, they assumed custody control, the responsibility to maintain that, repair it, when necessary, replace it, because those alterations, when done, as has been said today, they can cause leaks into the cavity of the walls, leaks into the unit below. They can cause leaks into the common elements, and that's exactly what has occurred here. So the court made that finding, the trial court made that finding that this unit was altered, it was converted. In 1997, there's the construction plan. And the court went through that. The trial court noted the testimony of the association's expert witness, David Cairns, who has worked on site as an engineer for decades at Fisherman's Haven, and finding that these leaking interior lanai windows were not original to the building, but they were the result of a prior owner's alteration. And it's undisputed that, again, that the Hazeltons took title to the unit subject to those recorded declarations. No dispute that there was water infiltration that was causing damage to their unit, the unit below. Now, the trial court very correctly dismissed this argument, this to muddy the water, this argument that they've raised again and again to avoid their obligation. You know, there's this statement that, hey, if the association had just done this years ago, we wouldn't have been in here. Well, the unit owner too, whose obligation is, and no other unit owner at Fisherman's Haven has ever rejected this obligation when they have a converted balcony to interior lanai to maintain, repair, replace their ulterior iteration. But they made this argument that the upper window flashing, that was the lone source of the water intrusion, that it was not part of the leaking window system, and that it predated the lanai windows, and that was original to the construction. This was a way to make this argument that it was a common element. The trial court found that argument to be unavailing, unsupported by the evidence. Now, they also make other arguments, and we've heard today, that are entirely without merit, contending that this property management agreement made the unit alteration a common element and obligated the association to make those repairs. That's entirely without merit. The association was not a party to that agreement. But more importantly, the court didn't make any factual finding that some property management agreement made these windows a common element, or that it obligated the association to make those repairs. Rather, Judge Carroll maintained the matter of law interpretation of Judge McHugh and Judge Bruning before him, that when Judge McHugh granted partial summary judgment prior to trial, that the plain and unambiguous terms of the declaration of Section 10B in place in 2009, when they purchased their unit, places that duty of maintenance, repair, replacement of unit alterations on the Hazeltons as the unit owner. Now, There's also this discussion of an inadequate remedy at law. Now, we referred to the Hobbs v. Weinkauf case for the violation of Chapter 718 when proven that itself constitutes irreparable harm for which the statute 718.303 authorizes injunctive relief with no additional showing. When there is no adequate remedy at law, it's because there is harm that's considered irreparable. Here, it's the stubborn, adamant refusal to acknowledge maintenance obligations of unit alterations, and this other unusual and persistent position that the unit alterations are common elements that should be the association's responsibility. We referred the court to the Briarwinds Condo Association v. Rigsby from the 3rd DCA. Same position. Violations of Chapter 718 of the Declaration authorize injunctive relief to compel compliance, to resolve those violations. We referred the court to the Hollywood Towers, the 4th DCA case, Hollywood Towers Association, and the Mitchell versus Beach Club Hallandale Association. In each of those cases, the court found that either the owner or the association failed to comply with the Declaration or Chapter 718 that constituted irreparable harm. Now, the two cases, and there was some mix-up as to whether or not counsel was saying Mariello or Emilio, and the other case of Alorda versus Sutton Place Homeowners Association. But starting with Alorda, it dealt with an HOA's ability to force place insurance and then charge the Alordas back for the cost. That's a one-time transaction. There was no contact with the owner. The owner didn't claim it was the association's responsibility. And it certainly didn't require what we have here is it would take repeated physical entry into the home, into the interior, to make invasive repairs, assume liability, take on ongoing maintenance. And in Alorda, it was determined that, in fact, the insurance had been put in place before the case started, rendering the case moot from the beginning. And so the only issue on appeal was attorney's fees. It's not applicable. Now, Mariello, cited by the appellants, is also distinguishable. It's an HOA that was requiring or seeking to require the owner to mow the lawn, trim the hedges. Doesn't require taking possession of the interior of the home for weeks, for months, for invasive and this complex work to repair water infiltration, causing damage to other units and the common elements. It was also, importantly, procedurally distinguishable as those owners had sold the property and the new owners had mowed the lawn and trimmed the hedges. So remedying those violations, again, on appeal was only attorney's fees. And although there's no requirement, because we showed the violation of Chapter 718 in the Declaration, to show irreparable harm without inadequate remedy of law for injunctive relief, beyond those continued violations at trial, the association certainly nevertheless established, and the trial court found, hey, there was a lack of an adequate remedy, and that granting the injunctive relief is in the public interest. Now, when a kind of assumption that's made is that, hey, these other condominium declarations don't give the association here the similar option to either, at the association's discretion, make the repair or compel compliance through injunctive relief. That's simply untrue, and the trial court noted that that was similar to most condominium associations that regularly have those options at its discretion. But the crux is this self-help argument. The association should step in and do what the unit owner is supposed to do, but won't do. This would require a voluntary board of directors to take control, enter the appellant's unit. An owner here who is a contract law attorney who said, now they say, go in there and do it, we'll fight about it later. And it would require performing invasive work, entering the unit, moving their furniture, moving personal items, taking down window dressings, and then performing those kind of phases of removal, performing repairs, installing the new windows, and then repeated entry thereafter for maintenance for the windows that are installed, maintenance going forward. And that does not serve the purpose of the declaration. We noted in our brief that in order to be considered an adequate remedy, in order to preclude injunctive relief, that available remedy must be plain, certain, prompt, speedy, sufficient, complete, practical, and efficient in obtaining the needs of justice, similar to calling an insurance company and place ordering insurance, or sending someone over there to mow the grass. And this was the Lisa Danielle Inc. versus Jamco, a third DCA case, requiring, again, not to belabor it, board members to repeatedly take control of an attorney's unit, take possession of it, perform work over a period of time, maintain it going forward is not certain. It's not speedy. It's not complete. And it's certainly not efficient in obtaining the needs of justice. Under the declaration and under Chapter 718, the legislator has provided that if a unit owner refuses to comply with the declaration, or if an association refuses to comply, that they have the ability to seek compliance through injunctive relief. And again, no other owner has ever failed to maintain their alterations, their additional interior living space. Stepping in also to make that repair is not an adequate remedy. That would resolve harm that's already occurred. It would not prevent future harm, future noncompliance, the ongoing requirement to maintain, which we see here that they've always rejected, that it continues to be a common element that they continue to reject today. We've made this very clear, that they believe it's the association's responsibility. This adequate remedy, this self-help argument also implicates the business judgment rule. And that's the decision of the board of directors to enforce compliance, to enforce compliance if the owner won't through its right of an injunction action. As argued at trial, the board of directors' decision to enforce the provisions of the declaration against owners who are violating, non-complying, to compel that compliance, that decision is entitled to deference. Now, as I mentioned, we're talking about an owner who is an attorney.
FYI, you have about 30 seconds left.
Okay, so prior to to suit being filed, the board requested that they participate in pre-suit mediation. That was unsuccessful. Even in their brief, they continue to reject that obligation. The decision of the trial court correctly applied that judicial deference. The substantial competent evidence that was presented support injunctive relief granted by this court, and we're at an abuse of discretion standard, and the trial court's decision should be upheld.
Thank you, counsel. Mr. Manganiello, you have 3.5 minutes remaining.
Thank you, Your Honor. There's a lot to address, and I'll try to be very quick. 718-303 doesn't expressly authorize injunctive relief, particularly not in situations when there's adequate remedy at law, as Aldora and Moriello clearly stand for. If the association is having a dispute over the responsibility and a unit owner saying it's your responsibility, they're saying it's ours, that's a declaratory judgment. That's not the extraordinary relief of injunctive remedy. And again, that goes to exactly why there's also not a clear legal right, which would support the injunction. Very, very important point. If a unit owner makes a modification, that language does not convert this to something other than a limited common element. It's still a limited common element. There is nothing in the declaration that makes it possession, take title, somehow owns it. It's absolutely not in the declaration. Please, read the applicable section 10b8 at your leisure. It is still a limited common element. It's just one that if a unit owner makes a modification they have maintenance responsibilities over, they don't take possession to it. These are exterior windows. These are exterior to the unit. I put the boundaries of the unit are very clearly outlined, and it's cited in our brief. But the interior of the unit goes to the bare wall of the outer unit and stops. That's the space of the unit. Everything outside of that, which is where these windows are, as established at trial, are so they're external, so they're limited common elements. And there's nothing in the declaration that makes a unit owner modification somehow not a limited common element. In fact, it's contemplated to be a limited common element when you read the declaration. It's just one that shifts responsibility to a unit owner if they make a modification. Again, what Mr. Hazelton took notice to when he bought the unit was if he made a modification, or if a unit owner had made a modification after 98, they would have to maintain it. In this case, this modification was made in 1997. It's not if a unit owner makes, again, if the language said unit owner modifications, we would be having a completely different conversation. It doesn't say unit owner modifications are unit owner responsibilities. It says if a unit owner makes a modification, that language didn't come into place until 1998. And again, there's nothing in the declaration that absolves the association of the responsibility to maintain limited common elements. While this section addresses future prospective modifications by unit owners, it doesn't in any section absolve the association of their responsibility. Again, what we have here is just the absolute recipe for why the injunctive relief is, particularly mandatory injunctive relief, is such a rare, should be very seldomly used cause of action. If the association had simply done the repairs, which they unquestionably had a right to do, or replacement, as Mr. Hazelton offered. Oh, I do have to address this. They talked about I'd have to continue to maintain, I'd have to continue to go in. The injunctive relief sought was to replace the windows. The injunctive order requires the replacement of the windows. There's no injunctive order entered or sought for continuing maintenance of those windows. That wasn't an issue. As the court may or may not know, this injunctive order, the parties worked it out and have complied with the injunctive order. It's the case
I
isn't
need
moot
to let you
because
know
there
that
are
your
still issues
time
of attorney's
has,
fees.
Expired a little bit
Thank you,
ago.
Your Honor.
I
I
thank you.
appreciate the time. Thank you.
Not a problem. Thank you both for your excellent presentation. Take care, stay well, and the court will see you the next trip. On
Thanks so much.
perhaps a different case.
Thank you, Your Honors.
Stay well. This will move now to our last case on the docket today, which is the City of Largo and Lyles.